There is a question here that I do think does implicate whether we are going down a road to politicize the ethics rules. It is no coincidence that all of the people who find a particular part of conduct objectionable, and this is not, a virtue or a failing of either of the political parties. It's just part of, the political process. All of the people that find something objectionable, almost to a person, although not necessarily, there are some exceptions, tend to be people of the opposite party. You would not have seen people clamoring for an ethics investigation in the current political environment of those excellent lawyers in the Department of Justice who somehow have advised AG Holder that DC may be given voting rights by statute. This would not seem, on the face of things, to be a particularly competent application of any legal principle. And one would not think that that this is a question that you actually need to delve into a lot of legal documentation, say, beyond the text of the Constitution to actually gather. But there is no hue and cry for such an investigation, nor was there a hue and cry in the 1990s where the Office of Legal Counsel during President Clinton wrote any number of memos which I could set side by side with the memos that were written in the last incumbent administration and say, many of the things you are saying are wrong with these, I could identify as failings with this. And to me, if I am able to do that and to demonstrate to you that that's true, we do have to raise the questions whether we're allowing the ethical rules to be turned into an instrument of political warfare. We are starting down on a path where we may not be able to turn back once we get on it. And I will just ask you in conclusion to sort of think about this fact. 22 years ago, there was a fairly qualified fellow by the name of Robert Bork, who was nominated to be a justice of the Supreme Court of the United States. He got massacred in a really ugly and ad hominem way in the Senate, and so much so that his name actually became a verb. Now everybody understands what borking somebody means. And to no one's great credit, each party has done it in succession since then. This is not to say that the Republicans don't do it and that only the Democrats do it. Each party has done it. And once you start down this road, once you take the rules that set the profession apart, that makes us have a certain set of distinct duties as lawyers, that turn those as weapons for the political process, you can have no doubt that the next set of our crazies will be filing ethics complaints against everybody in the Obama administration, and some significant number of flack senators on our side will be saying that it's the most outrageous thing that they ever heard. And I think we should all pause and consider whether the rules that set us apart as a profession are really suitable for this sort of use, and whether this use of them is consistent with their intended value to us as lawyers. And that's what I have to start the discussion started.
All right, before some questions from the moderator and from the audience, why don't you each take a few minutes to respond to what your co-panelists have said.
I won't say much. This on? Hello. I'd rather hear questions from the audience, actually. I think the issues are pretty well framed for us to talk about. Do I have anything to? No, I think I'll just wait for questions.
Okay, well then I'll pose one. Well, I think the first question I'd like to ask is, Mr. Estrada suggested that there might be a double standard at work here, and he also suggested that we ought to be alert to and wary about the possibility for political gamesmanship, political retaliation. And perhaps you'd like to address yourself to that.
Sure. Yeah, I hope there isn't a double standard at work here, and that's really, that's my hope. I mean, this isn't a strategic posture that I'm taking. I mean, I'll out myself as someone from the other side of the political aisle. I'm a Democrat, and an Obama supporter, but I genuinely do believe that we can have this discourse in a neutral way. It's not a pose, and so I think it's possible to criticize memos from the Clinton OLC as well. And if those are equally tendentious and flawed in the same way, then I would support discipline in the same way. This is an incredibly high-profile issue, so it attracts a lot of energy and attention. But I don't think this is unique to one administration. I will say, in terms of the administrability of all this works fine on the private side. You know, the world has not stopped turning because lawyers are occasionally held liable for giving overly aggressive judgment. Corporations, banks, all kinds of private actors get fairly aggressive legal advice all the time, despite the fact that lawyers do, on the private side, face a very real prospect of liability for giving advice that facilitates crimes or frauds, or that even results in harm to the corporation. There's a great case that I love to teach called FDIC versus O'Melveny and Myers, where the lawyers, I think, were a little bit too cute in trying to let the client get away with something that it wanted to do, and then the bank went into receivership, and the lawyers were sued for providing this advice, and the law firm paid a big judgment in that case. Settled on appeal. So private side lawyers have to worry about this chilling effect, and yet life goes on. And so I think it is possible to have an administrable system of rules that regulates legal advising. I don't think we have to withdraw from the field entirely, and I think that the symmetry of this is not a reason to withdraw either. I think the symmetry for this is a reason to be cautious, perhaps, and to be wary of the position that any party is taking, but I think it's not a reason to withdraw from the field.
Can I say something just briefly? I mean, I do think no one could fight with the proposition that ethical rules are as binding on government lawyers as they are binding on the private bar. And in fact, there's a statute that actually calls for that. And that's not really what's at issue here. What's at issue is whether the particular criticisms that are being leveled at some of these actions in the post-9/11 world really have a comparable private analog, and B, a body of doctrine that is distinctly developed enough so that it cannot be manipulated for political process. If you take the trouble to go look at the reported cases under Rule 2.1, you will find on the one side that several states until recently did not even have the rule in a mandatory form. It was a lawyer should render candid advice, which is just categorically ineligible for discipline to begin with. And you would also find in the second place that the number of cases that tends to make it onto the books that actually do involve discipline for failure to render candid and independent advice tend to be cases of an absence of independence in the core level, and it's probably no accident that there is a range of fairly entertaining cases, which I would think would not be that useful as an analog, that involve a lawyer who's having sexual relations with his client, which somewhat unsurprisingly leads courts to conclude that the lawyer has lost independence. Now, I think what's at issue here is whether we really want to take cases of that site where the lawyer is literally in bed with his client and turn that into a rule to be applied when somebody in some sense can say that the lawyer was metaphorically in bed with his client. And I think that that's a big gulf, and there isn't really a lot of doctrine out there beyond the bare language of the rule, and the bare language of the rule does not contain administrable standards that will not be subject to political opportunism.